You know that TikTok trend where someone finds out their boss was gossiping about them behind their back? Workplace gossip is no longer harmless drama. It can destroy your reputation, your job, and sometimes lead to legal action. I'm Mila, an employment attorney, and this is Punching the Clock. When workplace culture breaks down, I'm here to clock it. I'm calling out bad behavior in the workplace and breaking down the legal implications. So let's make sure you have the legal tools to stand up for yourself. Welcome to Punching the Clock. Today, we're diving into a topic everyone knows all too well: gossip in the workplace. Let's be real, offices run on coffee, deadlines, and yes, gossip. Some of it's silly, some of it's bonding, but what happens when gossip goes too far? And at which point does it go too far? When it stops being water cooler chatter and starts turning into harassment, retaliation, or even a lawsuit. That's what we're going to unpack today, and trust me, this is about more than hurt feelings. Gossip can get people demoted, fired, blacklisted, and in some cases, it can cost companies millions. So let's talk about it. Let me start with a question for you. Have you ever been the subject of office gossip? Think about that knot in your stomach when you know people are whispering about you behind your back. Now, imagine if that gossip wasn't just about who you ate lunch with. Imagine if it was about your sex life, your race, your disability, or your promotion. That turns it from gossip into harassment. If you know anything about me, you know I live, speak, and breathe in the fight. I authentically believe that because we spend so much time at work, the workplace should be a safe place, free of harassment, discrimination, retaliation. No one should ever dread going to work or have to deal with illegal behavior in the workplace. And here's the thing. Under California laws, employers can and will be held liable for letting gossip fester. That's not my opinion, that's the law. This isn't just theory, it happens every day and it's happening right now. Earlier this month, I stood at a press conference in San Diego to announce a lawsuit our office is bringing against the San Diego Police Dept. My client, a courageous, decorated officer, is suing the department for sexual harassment, discrimination, and retaliation. And at the center of it all, gossip that has created an incredibly hostile work environment for her. Gossip in the workplace isn't just talk. When it becomes a weapon, gossip can be used to destroy a career, prevent fair and equal treatment, or retaliate against someone. At that point, it's not just workplace drama, it's illegal discrimination. Now let's look at one of the most important cases on this issue. This case is called Miller versus Department of Corrections. Picture this, a California prison. The rumor mill is on overdrive. The whispers? That certain female employees were sleeping with their warden in exchange for promotions. Even if those rumors weren't true, the damage was massive. Every woman who got promoted was instantly branded as someone who slept their way to the top. Morale in the department plummeted. Reputations were shredded. The California Supreme Court came in and said this wasn't just harmless talk. It was a hostile work environment. The employer failed to meet its duty. The employer had an affirmative duty to protect employees from that environment. The message was loud and clear. When gossip becomes sexualized, targeted, or damaging, when it reinforces ugly stereotypes, employers must act to protect the targeted employees. This is their legal responsibility under the law. Now let's turn up the heat with another landmark case: Aguilar versus Avis Rent. At one of their California locations, Latino employees were constantly targeted with racial slurs and derogatory gossip. It wasn't just one-off comments either. It was relentless. It created a racially hostile workplace. Avis tried to argue, "We can't control everything our employees say," but the California Supreme Court disagreed. They held that once management knows this behavior is happening, they have an affirmative duty to stop it. This case established a major precedent. Gossip tied to a protected class like race, gender, disability, or sexual orientation isn't just unprofessional or toxic, it's illegal harassment. So let me ask you this. If this were happening in your workplace, would you feel safe? protected? Would you feel like management had your back? These laws exist because no one should ever have to work under these conditions. Now here's where gossip gets even more dangerous when it's used as retaliation. Say an employee reports harassment and suddenly the rumor mill starts churning. People are saying they can't be trusted or they're just trying to cause problems. This is not harmless. This could be career destructive and illegal retaliation. And under California's Fair Employment and Housing Act and Title VII of the Civil Rights Act, retaliation is one of the most common and costly claims that employers can face. Retaliatory gossip is sneaky. It often doesn't come with a formal write-up or a termination notice. It's quiet. It's social. It destroys reputations in the shadows. But make no mistake, it's still illegal. So what does all of this mean for employers? The law doesn't expect them to stop every whisper before it happens. But once gossip crosses the line into harassment, discrimination, or retaliation, employers must act. This means, 1, they must have clear, specific, written anti-harassment policies that spell out every protected category and how employees can report issues, including options beyond their direct supervisors. 2, training. They must provide training to all employees. The law requires interactive harassment prevention training every 2 years. And yes, that includes examples of gossip. Number 3, investigations. The law says employers have to respond quickly and thoroughly. That means launching a fair investigation, documenting everything, and if necessary, taking corrective action. And here's the kicker. Even if the behavior doesn't rise to the level of illegal harassment, the employer still has to do something. Coaching, training, warnings, some affirmative action that shows they are taking the complaint seriously. Doing nothing is never an option. And let's talk retaliation because this is where a lot of employers get burned. California law makes it crystal clear. You cannot punish someone for reporting harassment or participating in an investigation. And retaliation isn't just when the employer fires someone. It can be when someone is demoted, excluded from meetings, or yes, retaliatory gossip can also be retaliation. One more thing people don't always realize is employers in California are also responsible for harassment by customers, clients, or vendors. If a client keeps making offensive comments about your staff and you don't intervene, as an employer, you can still be liable. The duty to protect employees does not end at your company's 4 walls. And remember, one offensive comment can be enough to create liability under California law. Stray remarks, they count. And employees now have 3 years after a bad act to bring a harassment claim. So here's the punchline. In California, employers have to play offense, not defense. Hope is not a compliance strategy. Gossip is not harmless when it fractures your reputation, your career, or your peace of mind. When it's weaponized, it's not just drama, it becomes a legal issue. So the next time you hear someone say, "Oh, it's just gossip," when it comes to workplace rumors, I want you to remember this episode. Gossip can and does destroy careers. It ruins mental health of employees, and it can cost companies millions when it's litigated. If you're dealing with this right now, know this. You have rights and you're not alone. You do not have to let whispers and rumors define your workplace. In fact, you shouldn't. Review your company's policies, make a documented complaint, and call me if you need help. At the end of the day, gossip may sound like background noise, but when it targets, humiliates, or retaliates, it's unlawful, and employers have a duty to stop it. I'm Mila Arutunian, and this is Punching the Clock. Gossip does not belong in a healthy workplace, and you should not endure it in silence. Always fight back. If you've been the target of rumors or gossip at work, or you've seen it used as a weapon, share your story below. I may cover it in a future episode. And if you found this episode to be helpful, hit subscribe so you don't miss more workplace callouts. Protect your reputation, protect your rights, and as we say here at Antonia and Miranda, protect yourself at all times. And don't let gossip punch your clock.